All right, good afternoon. Thank you all for gathering here today and welcome to my inaugural webinar, Real Estate Excellence Expert Advice Series. We're elevating real estate expertise through engaging webinars that deliver essential education and actionable strategies for industry success. I'm very excited to say we're live and recording on Facebook. Our topic today concerns the new rules for Realtor Commissions, which went into effect on August 17th. Our purpose is to enrich our audience's understanding of insights and strategies regarding how the industry is handling the new rules and regulations regarding commissions and how they are being paid to real estate agents for their services. You will be hearing from our esteemed panel of speakers comprising the best and most experienced players in our real estate community. Each speaker brings a unique viewpoint from their specific area of expertise. And without further ado, our starting lineup. Bring into this experience 20 years of title insurance and escrow knowledge in 5 key states: Connecticut, Florida, New Jersey, New York, and PA. I'm John O'Connell, title insurance officer. Good morning or good afternoon. As a title insurance agent at Primetime Title, I review public records, dispose of liens and encumbrances found on record, and ensure a buyer is the owner of real property, free and clear of title defects. I also insure lenders in first lien position. As an escrow agent, my goal is to deliver security, protecting your client's funds by eliminating fraudulent actors, by ensuring wires get where they need to go, by using safe validation, and guaranteeing my checks are not compromised through the use of banking positive pay. My goal is to streamline the title clearing process and get you through a seamless closing. With the new rules, title agents such as myself will be reviewing contracts and commission statements to ensure realtors are properly paid without delay. Next up, licensed since 2006, serving his clients by making meaningful connections and building lasting relationships. Todd Maloof, our realtor extraordinaire. Good afternoon, Todd.
Good afternoon. Thank you very much, John. Yeah, been selling real estate since 2006. We specialize in making your homes stand out from the sales side, and on the buy side, making you as a buyer stand out so that in any sort of a multiple bid situation, your bid does not go overlooked by any seller. In addition, we also work with a variety of developers in the area, whether they're building homes for sales or whether they're building investment properties for rentals. We show developers how we maximize and push price in today's market, and we're able to make those products stand out so that they rise above the competition. We've been a great resource in the area for 30 plus years. Combined, a bunch of agents in our office. We've done a ton of work in the business over the years, and we rely on each other for help as deals come and go. So we're happy to help out and happy to make connections with new people that are looking to buy or sell. And thank you.
All right, thank you, Todd. Next up, taking time to walk his clients through every step of the loan process and support you from pre-approval through closing date, creating a stress-free experience. Licensed since 2013, John Pearson, our superb loan officer. Good afternoon, John.
Hey guys, good afternoon. Thanks, John. I'm with Loan Depot. Like John said, I got licensed in 2013. I started in December of 2012, so coming up on my 12-year anniversary here. For those of you that don't know about Loan Depot, we're a direct lender nationwide. My office is in Hoboken. I live in Hoboken. Our office is licensed in about 25 other states. So outside of New Jersey, we're able to help our clients for those moves, their family and friends that might be scattered throughout the USA. When it comes to us as a team, like John mentioned, we're just really trying to give that a good process, help navigate the kind of real estate market right now. For obviously, mortgages, rates, it's everywhere in the news right now. So it's been a pretty hot topic ever since COVID. So we try and be here to just try and educate, navigate, and just deliver a good client experience, because it can be a pretty stressful type of transaction for a lot of people. Buying a house, taking out a mortgage, it's a big step in people's lives. So we're just here to help support, make sure that goes smoothly, and take advantage of some good rates.
Right on. Thank you, John. And finally, but certainly not least, opening his law firm nearly 30 years ago with the vision of breaking things down to work smarter, Brian Kapik, our brilliant real estate attorney. Good afternoon, Brian.
Thank you, John. Nice to see everybody. Yes, doing this for almost 30 years. Real estate's one of our main concentrations, what we do, and been working on for the last 30 years. Whether that's going to be a purchase, whether that's going to be a sale, residential, commercial, land use, condominium conversion work. We can help in all aspects of that, and are looking forward to this talk today. Thanks, John.
All right, thank you, Brian. We'll be getting back to you gentlemen in a moment. Now, I believe we can all agree this real estate commission settlement marks a pivotal moment in real estate, reshaping how commissions are structured and paid. To understand the implications of these changes, let's break down the new rules intent, what's happening, and why it matters. For years, the real estate industry has operated under a system where the seller traditionally covered the costs of the buyer's agent's commissions. This practice was rooted in the idea that it incentivized agents to bring buyers to properties and streamline transactions. However, this model faced increasing scrutiny over the years for being opaque and potentially unfair. The recent settlement addresses these concerns by altering the way commissions are handled. Starting August 17th, the rules require a significant change. Buyers may now be responsible for paying their own agent's commission. The new rules aims to bring greater transparency to the process. Buyers see clearly how much they are paying for their agent services and can negotiate those fees directly with their agent. Buyers will need to plan for this additional expense up front. This change shifts the financial responsibility away from the seller to the buyer, potentially impacting how buyers approach their home purchase and how they negotiate deals. Agents must provide detailed disclosure of their commission structure and any potential conflicts of interest. This will help buyers make more informed decisions and ensure that they are fully aware of what they are paying for. For buyers, this new rule can be a double-edged sword. On one hand, the direct payment system might encourage more negotiations and potentially lower commission rates as buyers become more proactive in managing their costs. On the other hand, it could increase the upfront financial burden on buyers, particularly in a competitive housing market where every dollar counts. Sellers might find this shift to be beneficial as they may no longer have to account for the buyer's agent commission within their sales price. This could make their properties more attractive to buyers looking for a better deal. However, this may also mean sellers need to be prepared for a potential drop in buyer interest if the new structure impacts affordability. Agents will need to adapt to this new model by clearly communicating their value proposition and establishing transparent fee structures. They may need to enhance their service offerings and provide more compelling reasons for buyers to invest in their expertise. As we move forward, it will be crucial for all parties to adapt to this new environment. Open communication and a willingness to embrace change will be key to navigating this transition successfully. For buyers, staying informed and being proactive in understanding their costs will help make the best financial decisions. For agents, this is an opportunity to redefine your value and build stronger, more transparent relationships with your clients. While these new buyer commission rules represent a significant shift, they also offer an opportunity for a more transparent and equitable real estate market. Embracing these changes and adapting to the new landscape will be essential for thriving in this evolving industry. And now on to our featured speakers who will be discussing their outlooks on the new rule, how they are playing out so far, and whether we could potentially continue business as usual. You may have seen him at one of the four corners of the continental United States, having himself traveled to Seattle, San Diego, Miami, and Limestone, Maine, with his key to success, effective and clear communication with all parties involved to create a successful and seamless transaction, our Realtor extraordinaire, Todd Maloof.
John, I think, did you like come over my house last night and just read over all my notes? Because what you just spewed was exactly what, we're talking about. And, there's a lot to break down on what you said. There's a lot of changes that are going to be taking place. But on the flip side, this is still business as usual. You can still conduct and purchase a home and transact in a piece of property the same way that you normally could. The only thing that these changes do is allow for the buyer to pay the commission side of the broker's fee in order for fee of service on the buy side. And it also allows the seller to not make that payment to the buyer's broker. A lot of this stuff kind of stems from these lawsuits, and these lawsuits happen all the time. And really, when the market's hot, we've had a good run over the last 11 years or so. That's when practices and professionalisms tend to dip. When that dips, it allows for poor practices, and it also allows for these lawsuits to come and target the real estate industry, because the real estate industry and the way that the commission structure has been sort of a ticking point for a lot of people over the years. The big misconception is that commissions are negotiable. People didn't understand that. And that misconception led to consumer confusion and these allegations that customers didn't really understand that concept of a home. The settlement goes on and on. There's stuff in there that says that realtors were baking in their buyer broker commissions into the price of the homes, which argued that they inflated the prices unfairly to enrich the brokers. This led to these class action lawsuits and yada, yada, yada. You can go on and you go to a whole rabbit hole and learn more about all this stuff. But at the end of the day, you have a buyer and you have a seller and you have a home that they're negotiating. And when the market is hot, there's activity. And when there's activity, you have a seller that hires a realtor, they put on the market, they get 15 offers, and then they kind of walk away going, what did I just pay for? That's in a really good market. But in a really bad market, you could put a home on the market, wait 6 months, you don't get anything. And meanwhile, you got a realtor that's pounding the pavement every day trying to find a buyer, and they still hate their realtors. So, we can't win either way. But at the end of the day, there's a couple results that were a direct settlement based off of what happened here. The National Association of Realtors, or NAR, agreed to significant changes to a lot of these policies. They include prohibiting the display of buyer brokers' compensation of offers in the MLS. That was like the big thing that they had to do in order to kind of create more of a transparent, to me, I don't really understand why this makes it transparent, but they took down the listing side on the MLS. So when you look on the MLS, you'd see a home for sale and you'd see what the offer is that they're offering to the buyer's broker. That's no longer gone. That field would be taken off. What you can do is call up the other broker and say, hey, is the seller offering a compensation for a well-qualified buyer? And you're allowed to disclose that. The idea behind that was, if the fees were varying depending on the type of market that you're working in, agents were not bringing their clients to homes that were offering a less of a commission. In a sense, they were steering people away from those homes. That's not necessarily true in our market. That's not necessarily true overall, but I guess there are people out there that felt that was something that was happening. The other thing is that when you're going to show a home, you're now required to have a signed representation agreement with a buyer before showing them the property. And that also includes all the terms, including the commission details, are clear and upfront. So if I sign agreement with you, John, and we want to go see a home, before we even open the door, you and I have to have that defined, signed off, and submitted. What that means is, if we're touring in a market, in a 2.5% market, what I will do is I will do my best to get the commission paid by the seller. If not, I'm going to come to you and ask you to pay the difference. Now, if we agree to 2.5% and the seller is offering 2%, I am allowed to accept the 2% from the seller, but you and I have an agreement for 2.5%. So there's a 0.5 point out there that's going to have to be made up on the back end. John Pearson's going to get into that in a bit, but that 0.5 point will either come out of your pocket or it will come out of the deal in the form of a credit at the closing table. Let's see, what else here? These changes, so those are the two big changes. Those two changes really ensure that customers are aware that the broker commissions are not legally set and they are fully negotiable. So on the sales side, you have the option to offer a compensation to a buyer's broker, and that's a practice that's always been negotiable and beneficial for both parties. why you would want to offer a broker commission is you don't want to limit your buyer pool, and not have them come see your home just because, if a home is worth X, you're going to be spending a little bit more. That might price that particular buyer out of that particular home and ultimately out of the market as prices continue to go in an upward direction. Offering your compensation can make a property more attractive to a wider pool of buyers, keeping it competitive and facilitating a faster sale. So, like I said, business is still as usual. I have not seen sellers not offering commission yet. I don't know that that will change. I don't know that that's coming around the corner. It may happen sooner than later. Who knows? Time will tell. And then again, on the buy side, you'll need to sign a buyer's representation before viewing each property with your agent. And that's whether you're in person or a virtual tour as well. Not having a real estate agent represent you can lead to missed opportunities and unnecessary challenges when you're buying a house. Obviously, all of us in this room know that buying a house is a very involved process. There's a lot of steps, there's a lot of paperwork, there is just a ton of stuff going on. And if you're not working with the right team of people to get you from point A to point B, you could trip up. It can cost you a lot of money, and it may even cost you the opportunity that you're trying to go after here. So all of these things that we're talking about here highlight the importance of having a knowledgeable and experienced advisor on your side. Partnering with someone like myself is only going to help ensure that you're guided through this process from start to finish. I think that's pretty much what I have here. How am I doing on time?
You did excellent. You still have some time, but we're gonna keep moving on. I love it. We might have to come back and check in on you in a month to see if it's still business as usual, or if things end up getting shaken with how this new rule was intended to make happen. So thank you, Todd. I appreciate your time.
Well, you know what? We're gonna. I just because we were talking the other day, I think we're gonna have other questions as these other guys talk. So why don't we pave the way for them to take the floor?
We're on it. Thank you again, Todd. Proud resident of the birthplace of baseball, with the first game being played June 19th, 1846 at 11th and Washington Street, Hoboken, New Jersey. His key to success: find your niche within your business and become an expert at it. Master of the art of listening, the superb loan officer, John Pearson.
All right. Thanks, John. Yes, we all are, in this business, and as a craft, you need to become an expert at that craft. For me, with where I am being in that condo market right now, there is so much that you need to know from approving these buildings. And if you miss something, it can really jeopardize someone getting financing and the whole home. So something our team kind of takes pride in is just really understanding the dynamic of lending, the products that are available, what works, what doesn't work, and just setting things up and structured correctly. To the NAR thing. So the question becomes how buyer decides that they are going to be paying the buyer's commission. So on the contracts now, it's outlined, what's going to be paid and what's not going to be paid. The buyer has two options. Number one, they can just pay it out of pocket. So as a lender, if we see that right now, not only are we verifying that a buyer, qualifies for the loan, they're going to have enough assets for their down payment, their closing costs, and thus having to pay that commission. So not that it's a crazy big deal on our end, but as a lender, we're going to need to verify that all those funds are there and available so the deal closes smoothly. Now, in the event the buyer says, okay, I'm going to pay the buyer commission, but I prefer not to come out of pocket with that. I want to finance that into the purchase price. That is certainly an option. So what would happen there, depending on what commissions need to be paid out, once a purchase price is set, the agents are going to have to say, okay, based upon this, we're going to have to increase our purchase price by, let's call it 2.5%, which is the buyer's commission. The buyer is now financing that into the loan and getting that credit back at the time of closing. What's kind of neat with that is anytime that you have any type of credits coming back from, because technically it's coming back from the seller, it's considered an IPC, interested party contribution. So depending on your loan program that you're going with and your down payment, you're capped at certain percentages that a seller can give back. and those percentages can't exceed your total closing costs. When a buyer elects to finance these commissions, that financed amount does not eat into that IPC or interested party contribution. So in the event that it's 2.5%, you can finance that, and your loan program says the max seller credit's 3%. It doesn't mean you only have a 0.5% left back from the seller. And what those credits can be is typically inspection things, any type of prepaid maintenance on a condo. So a borrower can still take advantage of their full, seller contribution amounts, even in the event that they are financing that into the loan. So they don't have to worry that they're kind of saying, oh, shoot, I can only ask for X amount from the seller because I only have a 0.5% left of, seller credits available. The only thing that might get a little tricky on that is the appraisal piece of it. You see sometimes, hot properties, they're going higher in terms of price. You then need to make sure that if you're increasing that price by another 2.5%, that home's going to appraise. In the event it doesn't appraise, that buyer will either have to go back to the seller and potentially renegotiate a purchase price, or come out of pocket for that delta to pay their agent. So I think it's just very important that when you're structuring these contracts, A, from like a realtor perspective, and B, from a lender perspective, is you're just educating that borrower of potential outcomes. You don't want to have that happen, and all of a sudden, you're having that conversation with them for the first time, and they're saying, wait, what? I didn't know this. What's going on? What does this mean? I can't get this specific rate or program, whatever the case may be. So I think, as it's always been, kind of setting proper expectations is super critical, not only in the real estate world, but I think in any profession. It is so key and important, but now more than ever, you really have to make sure that the realtor, the attorney, the lender, everyone's on the same page, and you're kind of outlining, hey, this is A, B, and C. These are the outcomes in the event this doesn't happen. So when you are faced with that situation, you revert back to what you guys talked about with all the notes and it all outlined, and you just decide, okay, how are we proceeding with this? That's pretty much the biggest thing of how the NAR is affecting us as a lender. Again, just verifying funds, factoring in any types of concessions coming back from the seller. And then what's also important is if you're working with someone that they're going to be using good appraisers. Appraisals are more key than ever, even in a tough market. So you want to make sure a lender is ordering an appraisal with a local appraiser, someone who understands the market. This place has deeded parking, outdoor space, a view of New York City. All that is very subjective from a value perspective. So, you need to make sure that appraiser is familiar with it. They understand what's going on. That way you're not getting somebody out of market that comes in, blowing up your deal because that appraisal just came in light. So aside from that, from like a lending perspective, kind of just business as usual. So we haven't run into many issues, obviously pretty new with all this so far, knock on wood, nothing, detrimental or, any deals dying, but just, again, things to be aware of and just making sure people know what's going on, educating them throughout. And I think that's just going to ensure a smooth transaction.
Excellent, John. Thank you. Thank you.
Sure.
Loan Depot with the resources and tools. Always. Thank you. Next up, with his key to success being communication, he breaks down difficult concepts so his clients understand their legal rights from contract through closing. Claiming Hey Jude was the Beatles' most popular song, our brilliant real estate attorney, Brian Capek.
Thanks, John. Nice again to be on here in terms of talking about topics. I'm going to jump on what Todd was saying. On my end of it, it's kind of a little bit, I feel like a little bit of a Goldilocks scenario. Todd is dealing with the hot topic on the front lines, right? Because now he's having to talk to buyers about agency agreements. John's starting to see a little bit of it, but not really, a tremendous amount of it. I'm seeing very little, okay, in terms of change and where business is more of usual. Up to this point, I've had one client who wanted me to work with them on the agency agreement, on understanding it, how it played out. and how that was going to work with their relationship. I'll be honest with you, I think in that particular fact pattern, once I got to the end of working on the agency, I just think it was the agent did a poor job of really explaining what it is. So they kind of dished it onto the buyer, and the buyer's like, whoa, what am I getting myself into? Rather than walking them through how the practicality of this is going to work. But I'm with Todd, and I know John was kind of finishing up on business as usual. I'll work off of that term. Whether business as usual, maybe that's maybe not the exact term, but I don't think in this area we're going to see a lot of change ups. It's interesting to listen to what Todd said, right? Before we have a listing agreement that tells the buyer's agent what they're going to be, what the compensation is going to be. And now what happens? Don't disclose it. Don't put it on the listing. But hey, Todd, how much are you going to give his commission on that listing? Is where we're up to now. That seems like we're going from, something that's very clear to the dark ages, but we don't want steering. But maybe if I don't hear from Todd on the phone what I want to hear, maybe I'm not showing that property versus my buyer who's got access to Zillow and everything else that's out there and knows about that property and is saying to me, hey, Todd, why aren't you showing that property or taking me to it beforehand when there's commissions laid out? Now it's kind of done on the down low, for lack of a better term, which is unusual and I think strange, right? In terms of where that part's coming out. But how else are you going to do it, right? For two reasons, not even just in Todd's role, but in the buyer's position. The buyer, in reading through the agreement, right, I talked about a couple different things. One, I could show you properties in which there's going to be is going to be where it's going to be compensated, specifically where I'll be compensated. Those will be the only ones I show, or other ones where it's more wide open. So I think like everything else, you're going to run into a couple things as we move forward. You're going to get what I call the bottom dwellers, right? The bottom dwellers on the sell side are going to be like, hey, Todd, I heard there's this new thing out there. I don't have to pay the buyer's agents anymore. All right, sounds great to me. So I guess I give you 2.5% or 3%, and we're good to go, right? So Todd, as Todd would do, is educate them of where there may be disadvantages to that. Maybe there might be advantages to that part of it, depending on the scenario. But I think at the end of the day, just like everybody else, if you're doing that, you're going to narrow down the group of people that are going to be looking at the property. But again, being a bottom dweller, I don't care. The market's hot. Just sell my place and we'll go from there, right? But that's not the vast majority, right? That's not the vast majority where people are going to be. And then you're going to have the next group, which is completely uneducated. They don't understand it. There's something that came in. I heard I have to pay you now. Do I have to pay you? Do I not have to pay you? So, kind of on the theme of what, John O'Connell said in terms of, where I really pride myself on is that working through the communication. And I can tell you, the two guys, Todd and John Pearson, what they've been talking about. And obviously, John O'Connell, says always, you want to talk to me about title, talk to me about title. So you're dealing with people who want to make sure you understand what you're getting into and not leave yourself in the lurch of not knowing what it is. So, on that part of it, getting to these things early, having the conversations, these guys will do that. But if it's the case that you're using a different lender, you're using a different real estate agent, that's that part of it, you want to get super clear up front how this is going to work. All right. How is this going to play out? And once you know that, right, then you're educated of what you're going into. I know John O'Connell said to me, speak a little bit about appraisals today, and I think it's important. John Pearson led into it. So I'm gonna move over for a second on the appraisal part. So ironically, I'm working on a deal right now that has closing costs built in to the purchase price. So for those who are not familiar with that, this is something that's been around for a very long time. It sounds a little bit what I call legal fiction, but it actually has been going on, and there's no problem with it. And the way that works is you determine, right? John Pearson determines an estimate on closing costs. Let's say he says your closing costs are going to be $15,000 on that part of it. We can then look to, with the seller's consent, to increase the purchase price by $15,000. And the seller will give a credit back of $15,000. So it's a wash to the seller. What it does to the buyer is it reduces what they have to bring to closing. Okay, sounds like a good on thing. It's not legal fiction. It's actually real. That's there. But now the latest deal that I'm in on this part to kind of dovetail to what we, to what John O'Connor was saying to me to touch on is, I of course put the standard language into my side as being the seller. If the property doesn't appraise, okay, for the new price, but appraises for at least the purchase price, we will adjust the credit accordingly. Meaning, if I was selling a property for 500,000 and now it's 515 on that, and it appraises for 500, the buyer would have to move forward with the transaction with no credit. Okay, that's there. It would just be back to where we are. We're back to 500. Here's the problem. In the deal I'm currently in, it took a little bit of time to get to the bottom of this, but finally the attorney calls me and says, listen, my buyer doesn't have the money. All right, he can't do this deal unless it appraises for 515. If it appraises for 515, then he's got enough money to be able to bring with the closing costs. Now, two things happen there, right? One, that causes an issue for the deal. Two, if Todd was in the role on the buyer's side, or let's call it the buyer's agent side, you're obviously promoting somebody, again, and I'm dealing specifically with the market we're in around here, what appears to be a weaker buyer, right, in terms of what's coming on, right? They don't even have the resources to be able to come up with their closing costs, right? In this market where we've got people bidding over price, we got people putting down a ton of money to be able to buy property. When you're having something like that, that can be a red flag and that can make things a little bit more difficult. But to communication, if that's your buyer, right, the buyer just doesn't have the wherewithal to be able to do it, this stuff needs to be all worked out in the beginning, right, when that offer's coming in, so it's clear, because any seller's attorney that's worth their salt is going to specifically limit that to what it appraises for and not be caught with something that came in, at below 515 on my example, and then the seller is and the buyer says, well, I'm going to cancel the deal because it didn't appraise for 515 when the net amount is really 500,000. So that's an interesting thing in terms of where that goes. What's the ability, right? You could say, hey, you could build it in, but I think one of the key things are, do you have the money if the seller won't let you build it in, or if the seller will let you build it in and it appraises, for less than the inflated price? And I think for buyers, you need to be prepared, for thinking about that if you're taking on this this new area of building in commissions, okay, into what you're able to buy. The other part of it is, that we touched on before was, I said to you, kind of strange where we're going from disclosing information to where Todd's saying, hey, what's the story with the commission on this particular deal coming in? And for people who hear that, I think one of the things that concerns me is for somebody like Todd, you're like, well, why is he doing that? It's in the buyer's interest to know whether they're paying or not for what's coming in, right? But Todd's going into an agency agreement up front, detailing all out what it is. But what Todd's really doing is helping out the buyer to see if the commission is going to be paid. And as he said before, what I'm seeing right now is it seems to be very much that the agents, which I think is smart for everybody involved, are not sitting there saying, okay, great, let's just sit in our silos, offer no commission to the buyer's agents and see how all that works out, right? And the problem with that is because now you're going to just have buyers that are going to only go to a seller, to a listing agent. And not that, that has gone on for eons in terms of it, but you're limiting that pool, because if Todd's working with people that they trust on that part of it and they don't want to pay the commission, let's remember where this is, right? Todd's not paying the commission in this situation, right? The buyer's agent, it's the buyer. So he's trying to figure out what this is and where this part is going to. I think it's going to be very important to see that information is laid out and that they know what they're walking into, so that when they're dealing with the listing agent, they know what they're getting and how that's going to be able to move forward. And these agreements, I think, have to be explained out so that they're clear, so people know, what they're doing and what they're going into. The other part I would just say, in dealing with this end of it and what's coming into play is that a lot of people, as I said to you before, don't understand a lot of these things. So explaining it, walking them through, knowing what they can do. Like I learned something from John Pearson today in terms of talking about, the ability to build this in and that it doesn't affect certain parts of what they're building in It doesn't go to, specifically what those exact costs are going to be for them. So people don't know those things, right? People need to know that. And it is a newer frontier, right? We're in something that's literally brand new. They've also come out with now disclosure statements. Just to touch on that for a second, right? We're in a scenario where in New Jersey just recently passed, I believe it was August 1, but don't hold me to that, is where now you're in a situation where sellers are now filling out disclosure statements, right? Brand new, right? It's always been when anybody's asked me for that, I'm like, nope, it's not New Jersey, not the way it works, maybe in Pennsylvania, but not here. But now you're dealing with disclosure statements that sellers need to be. And that, just to touch on, because I'm probably starting to run out of time, on that one on here, I really say to the sellers that they really need to be speaking to their attorney when they are putting that together, because those forms inherently are not clear. And unless you have somebody with an expertise to really understand how to answer the questions, they're very black and white. And the problem with black and white is we know there's a lot of gray usually. And if you don't answer, and if you're answering it with a black and white answer and there's gray, now somebody can come back down the road and say, that's not what you said in your disclosure. All right. So we have to watch out for that. John, I don't know how I'm doing on time, but I'm about.
I think you were timing yourself, because I was just about to chime in. We got about a minute left if you want to wrap up.
Yeah, I would just say, in coming into this, really important to work with people that in the beginning, right, before you're going out to showings, before you are putting in your loan application, are explaining to you how all this works. And if you're not comfortable with this person, what they're saying, rather than telling you what you want to hear, don't worry about that. We'll get one of those filled out and maybe is slipping it to you before the open house, or, yeah, I got great rates, don't worry on it. Just submit that application, we'll be good to go. You need to be comfortable with the people you're working with, that they're explaining this out, spending the time and making you educated. So when you're moving forward, you're not getting to me saying, I don't know what's going on with the whole thing. I signed some form and this loan guy just tells me, or a loan gal, that, don't worry, we'll figure out that interest rate down the road. Okay. Those are things or red flags you just really want to move off of. Thanks, John.
Thank you, Brian. I think we really just tackled that topic, from all sides there. And Brian, you did a great job, summarizing Todd and John and bringing it all together. So thank you. So I hope everyone enjoyed today's webinar, finding it both informative and beneficial. Please don't go anywhere yet, because in a moment we'll be opening up a Q&A. But first, I would like to share that I will be sending a survey in the next few days. All survey participants will have an opportunity for a bonus. One of 3 books will be offered to you on how to grow your business and yourself. First book is The Connector Effect, The Proven Way to Grow Your Business Right Now by Ivan Misner. Giver's Gain, The B&I Story by Ivan Misner, and something a little different, The 7 Spiritual Laws of Success, a pocketbook guide to fulfilling your dreams, 1 Hour of Wisdom by Deepa Chopra. And for those interested, there will be an opportunity to schedule a one-to-one with me, an actualization session where we'll discuss you, your goals, and your mission and purpose. So now let's open up the final portion of today's webinar, the Q&A. If anyone has a question for our panel, you turn your microphone on now. And
I got one. Don't you guys feel that this is going to be just more confusing for buyers? just creating more work for everybody. It really doesn't accomplish much. Except maybe the steering part.
It does, and you're not wrong. One of the things that the big highlight that this all does create is just a lot more paperwork. With paperwork come questions. With questions come, cold feet. With cold feet become, people are getting scared and skittish. Here's the other thing that I wanted to chime in on that Brian had kind of mentioned. These buyer broker agreements, in my world, these are new to the state of New Jersey, and so are the seller's disclosures, right? It's happened to the top agents. It happens to everyone, where you take someone out, you show them a home, they disappear, And then you find out 3 months later they bought a home. With these buyer broker agreements, I fear that a scenario like this may, and it probably will happen, where now that we have to sign these agreements up front, we're going to take people out, they're going to ghost us, and then we're going to find out that they bought a house later. What that means is if they bought a house where the seller offered the commission, or they had to pay the commission, but you still had an agreement, guess what, Mr. Buyer? You owe the commission twice. And I can see people getting into a trend where they're signing not one, but multiple of these scenarios, and they are enforceable. And they will cause a lot of headache for a lot of these buyers because of the way this is now set up. So yeah, to answer your question, like, yeah, this is confusing. And by the way, it says at the bottom of these disclosures, like, don't sign multiple of them for this exact reason. But it'll happen. It'll definitely happen.
So just more litigation.
Yeah. Get ready, Capic.
Yeah. But what about what you might have covered this, John? With the, if you're building it in, now you might have issues where, the deals fall apart because now you have to have it appraised for even higher. Or maybe this person needed closing costs. I mean, there's so many, just make it so much more complicated, like.
Yeah, I think the biggest, what's I'm sure is going to happen down the pipe is a buyer goes, yep, like I have money for my closing costs. This is great. I want to roll in my 2.5%. Seller's not paying it. I'll roll in my 2.5% into the purchase price. It underappraises by 1.5%. The buyer goes through an appeal process. They always have to do that. Value stays. The question I think is going to arise is, can that buyer cancel the contract if say they didn't waive their appraisal? Say they don't waive their appraisal in that situation, but they're now tied saying, I'm going to pay it. What kind of recourse is there for that buyer or seller if there's no money there to be paid to the agents? So I think that's going to be probably a big headache for people down the road, and probably the biggest issue that we can see. Now, granted, say that does underappraise and someone's doing like a conventional loan, that's somewhat an easy fix. Same thing as if you're not rolling in commissions where they can just take a higher loan to value, pay PMI, so their monthly payments are a little higher. So now you're financing 81.5% of the home's value instead of 80%. My payments just went up $50. Not the end of the world there, but say you're doing it on a $1.5 million home where you need to finance 80%. You don't have those other LTV kind of backup plan Bs. Yeah, it's like, where is that money coming from and what happens to that deal? Does it just stall? Does it just null and void? So I'm interested to see what's going to come out of these with, on these attorney review riders and the verbiage there to either protect the agents or the buyer or the seller, and how kind of the two parties are going to, come together and meet.
Thank you, Blake. Anyone else have any questions? Got a few more minutes.
I have a question. I love Brian's perspective on how you think this might impact the attorney's role, whether it'll impact when they're getting engaged and their rate structure, and if you think that it'll move things closer to the commercial real estate process for the attorney's role.
Great question. At this point, I haven't seen where it seems to be going that way. I thought there would be a lot more coming in, especially initially, of just being inundated with people coming in saying, what is this? What's the form? Like I said, I had one client set up a conference call. We went through the whole 9 yards. And when I got to the end of it, I just said to myself, the agent did a poor job of explaining to them what they were going into. But surprising, I found it. Now, remember, like with most things, right? If I'm only seeing one incident of it, I'd love to say that means it's all going really well. But I got a feeling it's some of the opposite, which is, hey, here's the form you need to sign, okay, before we go out, blah, 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 blah. And they're like, oh, okay, great. So I sign on this one. And a lot of times with, with electronic signature, one of the problems is people don't read things. So I could tell you when even dealing on contracts, right? I'll be dealing with a contract all electronically signed. You're clicking it on, and then I'm talking to somebody about it. It's like, I didn't agree to that. I'm like, it's right in the contract you signed. Like, yeah, I thought it was all fine and blah, 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 blah. So that's going to be interesting how that end works. And again, not like Todd said before, right? If you signed it and it's there and you have it, you're responsible. Law doesn't allow for ignorance. There's no ignorance defense in law. But that doesn't get away from the bigger picture, which is Todd's not doing what he does, I'm not doing what I do, and John's not doing what he's doing, and John O'Connell also, so we can go into lawsuits, right? It's not where we want to be. That's not what we're doing for a living, in terms of that. So it's just going to be really important to see where that goes. But as of now, no, I'm not seeing a lot of that, like as you mentioned, on the commercial side, where that type of work is going to be more hourly work that you're going to do, in terms of working through, because of the complexities and what's involved in commercial real estate.
Yeah.
All right. Thank you, Faith, for the question, and Brian for the answers. Anyone else have any questions? Otherwise, we'll be wrapping this up. Last call. All right. Thank you. This was again, this was my inaugural webinar. I thank everyone for attending. Thank you very much to Tom Maloof, John Pearson, and Brian Kapik for their expert advice and opinions today. I really appreciate everyone for coming today, and I hope everyone has a wonderful, safe, happy Labor Day.